Welcome, everyone. Very glad to have everyone here, even if it's virtually. I am very happy to introduce our second distinguished lecture on human rights that the Center for Latin American Studies and the Center for Middle Eastern Studies here at the University of Arizona are conducting together. This is our second one. And this distinguished lecture on human rights is coming out of funding from the US Department of Education with our Title VI grants. So welcome everyone, and very glad that you can join us for this discussion on gender and land rights in peace building efforts in Colombia. I would like to introduce our keynote speaker. Oops, hold on. Sorry. Our keynote speaker, Donnie Mertens. Dr. Mertens has a PhD in social sciences from the University of Nijmegen in Holland. She is a social anthropologist and is an associate research in the Institute of Human Rights and Peace Building. She's also retired professor from the Pontificia Universidad Javeriana in Bogota, Colombia, and emeritus professor of Colombia's National University, where she co-founded the School of Gender Studies. She's also gender advisor, or has been, at the Office of the United Nations High Commissioner for Refugees in Colombia, and has been rapporteur of the historical memory report on violent land and dispossession in Colombia's armed conflict. And out of these comes La Tierra en Disputa, which is a report that was published in 2010. She was also fellow at the Woodrow Wilson International Center for Scholars in Washington, DC. And her publications in English really reflect a long trajectory of dedication to human rights. And these include Bandits, Peasants, and Politics, the case of La Violencia in Colombia, that was published in 2001. Also Colombia, Gender and Land Restitution, that can be found in the Oxford Handbook of Gender and Conflict, and was published in 2018. And of course, her latest book, which is Women, Land Rights, and Colombians' Transition to Peace, which was published in 2019. So she's going to talk to us about her book, Elusive Justice, Women, Land Rights, and Colombians' Transition to Peace. But before Dr. Mertens starts her talk, I'm gonna pass the word to Dr. Ann Betteridge, who will be introducing our discussant. Sorry. Go ahead, Ann.
Thank you very much. It's a great pleasure for me to be here and be able to speak with you today and introduce our discussant, Ruken Şengol. She's going to be speaking immediately after our speaker delivers her remarks. Ruken Şengol currently serves as Distinguished Research Fellow through UCLA's Promise Institute for Human Rights and the Center for Near Eastern Studies. She's an anthropologist whose work focuses on gender and sexual formations of sovereignty, nationalism, kinship, violence, memory, and displacement in the Kurdish borderlands of Turkey, Iraq, and Syria. During her fellowship at UCLA, she's introduced several innovative and interdisciplinary courses to upper-level undergraduate offerings in the departments of anthropology and gender studies. These include gender and militarism, gender, kinship, and the state, violence and memory in the Middle East, as well as co-taught courses on political violence in the modern world. I so look forward to this distinguished lecture, and it's a pleasure, as always, to collaborate with the Center for Latin American Studies.
So Donnie, if you want to, before Donnie begins, I would like to say that We will be taking questions and answers at the end. And if you can write your questions on the chat, you can write them as the talk is happening. Or you can raise your hand, but that sometimes it's hard to see if there are too many people on the screen. Thank you, everyone. And please, Dr. Merton, if you want to begin.
Thank you very much. So dear Professor Marcela Vasquez, Director of the Center for Latin American Studies, dear Professor Anne Batteridge, Director of the Middle East Studies, dear Ruken Sengul, who has the grateful task to give critical comments to my lecture from quite another point of view of it, or at least from another point of the world. I'm very honored to be invited to give this distinguished lecture on human rights. This talk is about the legacies of war and the search for remedy for victims of massive human rights violations during a period of war. My focus is on rural women victims, and my questions and conclusions are based on many years of research in Colombia. I did research on gender relations and women's rights during land dispossession and on internal force displacement generated by 50 years of armed conflict. And during the last years, I focused on the gender justness of the measures taken by the Colombian government to restore the rights of peasant women and men who had lost their land. The Colombian case is important in its own right, but also relevant for other post-conflict or peace-building initiatives in the world that include transitional justice measures. There are many reasons for this wider relevance, but two of them are outstanding, that is, the focus on land and the focus on gender. Land was a crucial issue in the historical roots of Colombia's internal warfare and in the transformation of its dynamics, actors, and motives over time. Colombia's very unequal rural property distribution was never resolved despite several attempts of agrarian reform. Therefore, access to land has been a central claim in all the years of violent conflict, in the search for ending the conflict between government and FARC guerrillas, as well as in the design of measures of reparations for the victims of conflict. Two events are of special importance for my analysis. In 2011, 5 years before the peace accord between government and FARC guerrillas, the government issued the Victims' Law for reparation and land restitution. And in 2016, land reform became the first pillar of the peace accord between government and FARC guerrillas. Both the land restitution policy and the comprehensive agrarian reform agreed upon in the peace accord promised to include gender-sensitive measures. Did these measures work? Well, I think the title of my book, Elusive Justice, gives a hint of the kind of answer you may expect at the end of my talk. Then the importance of gender. Since the year 2000, when the UN Security Council launched Resolution 1325 on women, peace and security, the role of women in peace building and the redress for the specific forms of violence inflicted on women became formally recognized in many countries. In Colombia, for instance, the Constitutional Court ruled on protection of women IDPs, internally displaced persons, and gender-based violence became typified and included in the Victims' Law, and at the peace negotiation table, both government and FARC areas considered, after some pressure by women's organizations, gender equity as a necessary element for building a more inclusive democracy in a post-conflict society. However, independent land rights for peasant women were still a cause to fight for. Since the 80s, rural women's organizations tried to uplift and dignify peasant women's position because they had remained at the bottom of rural society in terms of low social status and in public policy, they were deprived of rightful possession of land on their own. For a long time, rural development policies were what is called familistic, that is, oriented towards male-headed peasant families, and only men could receive a land title in name of the family. Since 1994, this measure was formally modified, but in practice it continued in all public policy. I will come back to this later. The Victims' Law on Land Restitution could be considered an opportunity not only to restore property rights, but also to contribute to the transformation of historically discriminatory conditions for peasant women. To accomplish this mission, the implementation of the law had to work on the intersection of two phenomena: the historical discrimination against women with respect to land rights and the special impact of violence that women experienced as victims and survivors. Land restitution thus became a kind of test case for the transformative capacity of transitional justice measures for women's rights. The legacies of war. Just a moment. Yeah. Over more than 50 years of internal warfare between guerrillas, paramilitary and state forces, Colombia's rural populations, particularly women, were the main victims. They were massacred, sexually violated, they saw their homes destroyed, they were forcibly displaced and violently dispossessed of their land. Between the mid-1980s and the mid-2000s, a time span of 20 years, over 6 million rural people, women and men, were forcibly displaced from their homesteads and sought refuge in the cities. In 2010, the Historical Memory Group and other organizations calculated the abandoned and dispossessed land. The dispossessed will say that it is the land seized by others in 6 million hectares, approximately 50 million acres. But how was this land taken and by whom? A short detour is necessary for a description of the complex dynamics of violence and its actors. I will take as example the Caribbean coastal area of northern Colombia, the region of my research, which has been known as a region of extensive properties, hacendados, big landowners, who exploited the peasants and rural workers. A strong and combative peasant movement, the ANUC, that performed land takings of haciendas to press land reform and to press redistribution among the rural poor in the 70s. The entrance of several guerrilla groups, FARC, ELN, EPL, in the 80s, and the birth and extension of the most murderous paramilitary alliance, the AUC, the United Auto Defense Forces of Colombia, in the 90s and until 2005, when they at least partly demobilized under the Justice and Peace Law. The paramilitary took revenge against the guerrillas, but also against the peaceful peasant movements of the past and against the peasant population. They murdered and raped and set fire to houses and whole peasant villages and generated an enormous flow of forced displacement by rural men and women. Frequently, rape was used as an instrument for dispossession, to make the people flee and then occupy their lands. The abandoned lands were occupied in a few significant cases by the paramilitary themselves or by their political friends, but mostly by others, big, middle, and small landowners who grasped the opportunity to expand their properties, sometimes former neighbors, and most important, new entrepreneurs, new agro-industrial and extractive companies. This all set the stage in 2011 for a complex land restitution program that involved social and geographical research and the final judicial sentence by special civil land courts. And notice, no criminal law was involved. This is civil law. And it was put forward and initiated before peace talks were held. So this was a very special situation. I will continue this talk with a reflection on the core idea, justice, and particularly gender justice in this all is elusive. Why? First, the idea of gender justice gains special importance in the context of transitional justice because the idea of transitional and peace building broadens the concept of crime and punishment in law, shifts the attention from perpetrators to victims, and extends the judicial field towards a search for truth and reparations. Land restitution, or more general property restitution, emerged as a new right in international law and became known as the Pinheiro Principles in 2007. Famous cases of these property restitution are at the end of the Bosnia conflict, South Africa, Liberia, Uganda, and to a certain extent, Guatemala. In the context of this property restitution, the concept of gender justice should also include, beyond equity, the notions of dignity, of recognition, and of agency. I want to tell something of the Pinheiro Principles and of other measures that were taken by the UN General Assembly that adopted a related set of principles on reparations for victims that include, and I cite, I quote, restoration of liberty, enjoyment of human rights, identity, family life, and citizenship, return to one's place of residence, restoration of employment, and return of property. Together, these two resolutions of property restitution and of reparations constitute a significant aspect of the new thinking on transitions to a post-conflict society, combining the right to return not only with the restitution of property, but also with a whole series of elements that are associated with the home, identity, family life, citizenship, livelihood, employment, reintegration in a form. So in this ample understanding of justice, beyond the strict letter of the law, we do not always share the same ground. Therefore, it is difficult to reduce this broad concept of justice to a single notion. It escapes from what some of us think should be its proper content. It unfolds in multiple notions coming from the different sides of enunciation of women and men who formulate or who impose justice or who receive actions of justice. In other words, its content changes from international schemes through policy formulations and public debates down to the personal experience of victims, peasants, women, and men. In this sense, a common sense of justice is elusive, and I will show this in the Colombian case. A second notion of elusive justice relates to the search for justice. That is the will to end historical and conflict-related gender inequities through public policy and/or judicial action. Concepts like affirmative action related to women or gender-sensitive approaches in public policy or in development, transitional and post-conflict programs, they need a closer scrutiny of its formulation, application, and above all, results. Some time ago, I found a book with the title The Elusive Agendas of the Gender Mainstreaming Approach, written in 1996 by Professor Jehan at Columbia University. I endorse his argument that the objective of transforming gender relations and creating a more just and equitable world through public policy is very, very far from being achieved. In the Colombian case, the search for justice through public policy and land restitution, based on the formulation of what they called affirmative actions, showed serious limitations, and I will explain this in detail in the following. In all these areas, gender justice is still elusive. Then my research, the concept, methods, and findings. I started my research project during a fellowship at the Woodrow Wilson Center in Washington for the academic term 2013-2014. That peculiar start involved a series of methodological consequences. As an anthropologist, I was far away from my habitual field work, and my information came basically from the written work of court rulings on land restitution. However, these written words constituted, as I discovered, a fascinating field of inquiry. In the following years, I analyzed over 200 court rulings in the Caribbean coastal areas of northern Colombia, the provinces of Córdoba, Sucre, Bolívar, and Cesar, complemented with my previous fieldwork experience in the same areas and with a few more recent interviews. One of my reviewers called this fieldwork legal anthropology. I prefer to call it a social legal ethnography, mediated by the representations of public servants and judges, and based on the description of violent conflict and dispossession, on the exercises of social cartography performed by public servants, on the testimonies of restitution claimants registered in the court rulings, and on the arguments put forward by the judges to underpin their decisions. Together, all these materials shaped a rich and diverse bureaucratic narrative that reveals both the proposed goals as well as the limitations and contradictions of the process, and above all, the gendered representations by rural society. For the analysis of justice for dispossessed peasant women, I have used Anne-Marie Goet's concept of gender justice, the definition of which is rather fluid, but includes both the formal legal political sphere and the private sphere. So I could use it also for personal subjective experience. I connect this concept to the 3 scales of social justice by Nancy Fraser: recognition, redistribution, representation, or participation, I will call it, and to Bernadette Attawin's notion of dispossession elaborated in her research on South African land restitution after apartheid. For Attawin, land restitution includes both material and non-material elements that she describes as a question of dignity, which makes us aware of the need to restore not only material conditions, but also the social and affective dimensions of personal projects for new livelihoods, and the rebuilding of trajectories and connections for a new social fabric. So, Attawin, this concept of Attawin refer also to the United Nations resolutions linked to property restitution. And finally, I borrowed from Anat Singh her notions of friction and used it in a slightly different sense to highlight the sometimes unexpected consequences of a global policy that generated in its local implementation new conflicts and new threats. Sometimes communities became even more divided upon return of the displaced because their land was taken by their neighbors, or families became unsafe spaces because the land was given back to a widow whose male family members felt passed over, or powerful agro-businesses that had been involved in land dispossession but lost their case in the courts. Sometimes this happened. They continued after land restitution to threat the returning peasant women by other, sometimes economic, sometimes violent pressures. The quest for gender justice in the land restitution process confronts adverse historical conditions. I started with a question: who owns the land? The answer used to be a man. Historically, peasant women occupied the twofold subordinate place in Colombia's rural history, in economic and in sexual terms. The historical rooting of power relations is based on the intersection of class and gender in the constitution of rural society, from the 19th century haciendas to the modern neoliberal extractivist and agro-industrial industries. I refer to the sexual prerogatives of hacendados as a mechanism of patriarchal dominance, and used as a form of patronage for binding humble peasant families to the power holders of the region. This was revived during paramilitary occupation of rural areas in the Caribbean coastal highlands. And they reveal how sexual, economic, and political practices of dominance continue to be intertwined, even when violent conflict has given way. And this is particularly relevant for the threats to women, and particularly to women alone, not to use the term heads of household, in the post-restitution process, as we will see. Sex and class dominance is also to be found in the persistence of the concept of familistic rural policy and practice. The concept comes from well-known researchers Magdalena Leon and Carmen Diana Dier, who wrote a famous book on gender and land rights in Latin America. Traditionally, in land policy, a deed was only given to a male family head. This practice has been formally abandoned to say it this way, of judges and even of peasant families themselves. An important derivative from the male-headed family model is the category female or women heads of household, that is based on the common idea of exacerbated vulnerability when an adult male is absent. And although this assumption makes the and violence by married women invisible, it has become a worldwide category embraced and still embraced by policymakers to materialize such a thing as gender mainstreaming. That is a consideration of the special situation of women in all policy implementations. In this concept, present of a man. An important deeds to all women claimants who've qualified for restitution. They gave a shared title with the husband. Yes.
Could you repeat the last? Could you please repeat the last section, because it was hard to hear.
Oh,
just maybe 2 minutes before now. Sorry.
Okay. Well, I don't know how much I read in 2 minutes. Shall I read the whole page?
Yes, please.
The quest for gender justice in the land restitution confronts adverse historical conditions. I started with a question. I started my research with a question: who owned the land? The answer used to be a man. Historically, peasant women occupied a twofold subordinate place in Colombia's rural history, in economic and in sexual terms. This historical rooting of power relations is based on the intersection of class and gender in the constitution of this rural society, from the 19th century haciendas of the modern neoliberal to the modern neoliberal extractivist and agro-industrial industries. I refer to the sexual prerogatives of hacendados as a mechanism of patriarchal dominance that was revived during paramilitary occupation of rural areas in the Caribbean coastal highlands. They reveal how sexual, economic, and political practices of dominance continue to be intertwined, even when violent conflict has given way. And this is particularly relevant for the threats to women in the post-restitution process. Sex and class dominance is also found in the persistence of a familistic rural policy and practice. The concept comes from well-known researchers Magdalena Leon and Carmen Diana Dier. Traditionally, in land policy, a deed was only given to a male family head. This practice has been formally abandoned in Colombian land reform policy, but it is still present in the heads, say, in the social imaginaries of practitioners, of topographers, of judges, and even of peasant families themselves. An important derivative from the male-headed family model is the category female or women heads of household that is based on the common idea of exacerbated vulnerability when an adult male is absent. And although this assumption makes inequalities and violence by husbands experienced by married women invisible, it has become a worldwide category embraced by policymakers to materialize such a thing as gender mainstreaming. In this concept, the supposed vulnerabilities of women without the protection of a man, and not because of the presence of a man. The land restitution program made an important step forward, giving land deeds to all women claimants who qualified for restitution, a shared title with a husband or partner, an individual title when alone, that is, when the claimant proved to be a woman head of household. And this was really a big step forward. The first time that women alone, as women head of households, could obtain a land title. So policymakers try to shake off the burden of the familistic model, but they maintained the head of household concept. Then a second gender-sensitive step was introduced in the program, the prioritization of those women heads of households in the administrative part of the process, in which the final decision by the judges, the legal part, is prepared. Later, I will evaluate this issue presented by policymakers as their first affirmative action. Finally, land rights have traditionally been based on male productive labor. Female unpaid labor and care activities, so intertwined with productive work in peasant economies, are not taken into account. In several interviews, I learned about cases in which women widows lost their claim to the land to their in-laws after their husbands had been assassinated or disappeared. The land was taken away by those in-laws as a normal and just thing to do, because she, the widow, had not been the main producer of the land. Most of these widows did not dare to present an official restitution claim. So the familistic and male producer model still constituted a barrier to the actions of justice provided by public policy. Well, I will now give an overview in detail of the land restitution program. The first part, administrative procedure. This procedure starts with a community assessment of the harms caused by violence, like assassinations, rape, forced displacement, land dispossession, and the place the claimant occupies in the family and his or her relationship with the dispossessed land. This initial procedure confirms the victim status, very important. And this is very important, and it is also crucial in the region I studied, the Colombia's Atlantic coast. Both land tenure and marital relationships were shaped by informality. This informality facilitated illegal usurpation and complicated the legal restitution process. Then the prioritization phase started for women claimant heads of households. In theory, this was a big leap forward in gender-sensitive land policy. To grant a land title to women alone and prioritize them in the process, it was a true affirmative action. But those women head of households, where were they? It was very difficult to follow them in the restitution process. The policymakers failed to monitor them. And in statistics, the politically so sensitive number of land titles handed over at the national level were not disaggregated by gender. Because of this failure, we don't know how many women alone, I prefer this expression, received a land title, nor where were they located, nor do we know about their families or production process or security. They got lost in territory. Exit are so celebrated affirmative action for women heads of households. The second part of the process is the judicial part. In the courts, the judge's view in the court cases, most of the judges fulfilled their duty to give a land deed to women claimants after investigating their victims' status and family relationships. Nevertheless, their decisions were influenced by traditional gender arrangement, and I discovered some significant examples of what feminist philosopher Miranda Fricker has called prejudice. Not believe a testimony coming from a suspicious person, leading to epistemic injustice. In one case, the judge found inconsistencies in the precise dates of rape and dispossession, testified by a poor Black peasant woman nearly 20 years later. Another judge considered a woman claimant did not qualify because she did not show enough agricultural vocation. The consideration never put forward in the case of men. None of these women got their land back. A more common phenomenon was the traditional gender blindness in the judge's argumentation. They still used to give a land title to a woman claimant due to their relationship with a man, even when he was dead. The widow of Juan Perez has a right to the land because before his death, he was registered in the Land Reform Institute. And that is why his widow gets the land. Or because the community says she was his informal spouse. Only in one case, a murdered man who left two spouses, a very common phenomenon in the Colombian Caribbean coast. I found a judge arguing that of the two women, the one who worked the land should get the title. This was revolutionary. I think the judge did not realize how transformative his argument was. But as we see, with this exception, even with a land deed, women need to confront traditional gender imaginaries. Then the third part of the restitution process, return and consolidation. The false idea of we go back to normal. In the Colombian program, restitution is conditioned by return. This is very important. No return, no restitution, no claim for justice. No considerations for monetary compensation have been made. And this is a serious problem for many women. They want justice, but they don't want to return. Sometimes another piece of land in another region is offered when security conditions are adverse in the original place from where she was displaced. Sometimes the police may accompany the ceremony of handing over the restituted land to give her an impression of safety. But what does this mean for returning women alone? The policeman could have been one of her rapists. The former occupiers of her land, mostly a powerful agro-business, lost the lawsuit, but are still nearby. They may wait for opportunities to get the land back by other means, through economic pressures or stalking, or even by violence. And perhaps she will sell her plot to them. Perhaps at a reasonable price. But is this a step towards more gender equitable, more democratic and inclusive land distribution? Other women, heads of household, return to the remnants of a community's social fabric, already torn apart by the destructive force of guerrilla and paramilitary violence. If she is extraordinarily strong, she might survive without social support. But most likely, she will again sell her plot after a while. At the family level, there is another risk. Many women claimants, now heads of household, must confront a former husband who after 20 years asked for his part of the plot. He is also entitled to, because they lived together when they were displaced by violent actors, but separated afterwards, as happened to many of the displaced couples in the cities. But then there is no money to pay a lawsuit for the division of property. Here again, what will they do? They can't live together. Maybe there are two families. The risk is very big that they will sell. There was also a woman, and this is just an example of many cases, who told me she claimed restitution but did not want to return to her plot, to the finca in the countryside. She preferred to return to the nearby village where she could open a little window shop, feel much safer than in the countryside, and nevertheless feel at home. So also this woman probably will sell her plot. This brings me to two conclusions. All these new threats may call into question. Let me make a question first. All these women wanted justice, but in terms different from the narrow definition of the law. So all these new threats may call into question the first step of gender justice through restitution. What to do with a land deed in your hands if the making of a new livelihood based on the land is too risky? Well, before coming to the conclusions, I want to give a short update of the connection of land restitution to the comprehensive rural reform agreed upon in the 2016 Peace Accord. I did not study this in my book, but it's very important to have a short vision of what is happening and what is the relationship of the two programs. 4 years after the signing of the Peace Accord, very little progress is made in the implementation of gender-sensitive rural reform. Implementation is in the first place hampered by scarcity of state lands for redistribution. In one of the monitoring reports on gender and land reform, it is stated that no activity or insufficient activity has been found. No adjudication of land to women, no special credits to women, no inclusion of women's initiatives. And well, another phenomenon which is important, most female ex-combatants go back to traditional care roles. This is not directly related to land, but it's an important context phenomenon. On the other hand, peace accord boosted rural organizations, and particularly rural women's organizations through the PDET, grassroots participative rural development planning, organized in the 14 municipalities most affected by violence. Thousands of social and economic initiatives were collected by the national rural development entities. And all the grassroots initiatives, and although it may take months or I think even years for the government institutions to build a regionally differentiated but that this participatory planning process, regional women's organizations were empowered and brought forward their demands along two axes: non-violence and access to land. But what happened with the restitution program and in these years and the search for gender justice? Prioritization of women-headed households was a failure and the action was abandoned. Instead, the focus has been placed on two areas of support for women with or without a partner in the restitution process derived from their observations on persistent patriarchal attitudes at the levels of society and rural women's constant exposure to external threats of gender-based violence or assassinations. In the last 7 years, 80 women leaders were assassinated. This is a very somber day. So the change in gender policy represented basically two actions. The women's program, civil servants, presented special family situations of women, but not only supposed vulnerabilities to the judges, like they were heads of household, or like they were a leader who needs protection, or being of old age. 35% of returning women is over 60 years old, or having separated, or having suffered sexual violence. So the judges may order additional measures for their protection to regional entities. Second, the women from the women's program in restitution organize, together with women's organizations, empowerment workshops for restituted women in which they learn about being a rights holder, about their land deed, and their own production plans, and they learned to be respected by husband and civil servants. As is here, they learned their real ownership to be respected. And even with the deed, this was not the case. They had to be learned, and they had to become organized in order to make society, community, and family members respect their ownership of the land. So both affirmative strategies can be seen in terms of Attaween's dignity restoration, or I prefer to call it dignity strengthening or establishment. In short, the new affirmative action supports women in their efforts to find a new and more autonomous life project and empower them at the inner circles of personal, family, and community life. In this sense, it is, or might become, a complementary process to the more politically oriented women's organizations in the rural areas of the country. So now I come to my conclusions. Gender-sensitive land restitution as part of a transitional justice program confronts both old patriarchal structures and gender imaginaries that persist in public policy and society among civil servants and judges, communities, and families. And in this sense, gender justice is still elusive. Starting my analysis with the 3 dimensions of justice I borrowed from Nancy Fraser: recognition, redistribution, representation, complemented with Atawina's dignity restoration. I have argued that the legal title over land for dispossessed women who never had got such a title before was an important step towards advancing gender justice because it represented a public recognition. But it was not enough. It embraced only one dimension of gender justice. I did not find progress in the redistribution of power and assets to women, and only limited progress of rural women's participation and representation in the polity, that is, in the political world of post-peace accord Colombia. I found obstacles for delivering gender justice in the way public policy was designed and implemented. I also found an adverse political, social, and economic environment for returning women to rural areas where traditional big landowners and new multinational agro-businesses lay down the law, and where formally organized rural communities had been destroyed by violence. In some areas, peace has brought more violence against new forms of female-led leadership. I found a persistence of negative gender imaginaries in rural communities and families that hampered the development of autonomous life project for women, the dimension of dignity. So, land restitution is not enough for a real transformation of gender relations in rural areas, but returning women might contribute to this transformation. Many of them possess new strengths. They survived violence and forced displacement. Some of them participated in urban movements and women's collectives, all formative experiences for resistance and leadership. Moreover, the empowerment of these new women landowners in legal and economic affairs may bring about changes in other roles in the household, in a new division of labor, in the economies of care, and in combating the threats of sexual violence. Starting from the transformation of the inner circles of family and community life, they can contribute to more just and dignified life in rural society. Thank you very much.
Can I go ahead?
Thank you very much, Dr. Merston, for a very insightful talk. I'm sorry about the little problems with internet, but hopefully people were able to imagine sort of the missing pieces.
Well, it may be my internet connection.
Well, that's okay. We got the gist of it. And I think now I want to let Dr. Schengel continue with her commentary and comparative perspective. Thank you.
Thank you very much, Marcela. Thanks to all of you, actually, the Center for Latin American Studies and the Center for Middle Eastern Studies for reminding me in. Thank you very much, Professor Meertens, Donnie, for an incredibly layered discussion of a notably complex and dynamic process of transitional justice that took place in Colombia. I'm just gonna be, it is I'm so very excited actually by the multiple layers of discussion that your rich, deeply ethnographic and processual treatment of this one particular case of gender-centered transitional justice, the restitution of the land rights of displaced women in Colombia in March, and the comparative insights or questions that it stirs for the cases of conflict and displacement in the area where I specialize in the Middle East. But I have so many questions in mind and on my notes, but I'll try to be as precise and specific as possible. One thing I think that what I want to start with is the powerful insights that your work offers into the larger debates on the contingency of national nation-state transitional justice initiatives with the terms and imperatives of political and economic globalization, or the often vexed relationship between the global regimes of women's rights or gender paradigms of development on the one hand, and geopolitical and governance interests of various state and supra-state and market actors in neoliberal times. Now I pose this macro level issues, I bring them forward because in my reading, these questions also lay at the formative background of the more specific issues that your lecture focused on. Can transitional justice initiatives bring transformation in gender relations? And you trace this through the ambitious project of instrumentalizing the transitional justice process in Colombia for the promotion of gender justice through this one particular project of land restitution of displaced rural women. Now we have here at least two layers, scales at which to assess the impact, the gender inclusive or gender egalitarian impacts of transitional justice initiatives in the context under consideration, which involves at one level it involves the question of legal enfranchisement of women. The legal enfranchisement of displaced rural Colombian women who have historically been deprived of the right to hold property in a patrimonial regime of ownership, and their enfranchisement in terms of the redress of the harms that they suffered through the process of displacement within the context of the internal warfare over the 1980s and 1990s. And the second scale in which this particular process that you justice process that you analyze also involves achieving gender justice in terms of the promotion of women's social citizenship rights, their socioeconomic rights. So at one point we are talking, you are considering, you're tracing in what sense this particular project have contributed or not to the recognition, to promotion of women's rights through women's citizenship status through the recognition of their rights. And at the second level, where the land restitution process is tied to rural development and the achievement of gender egalitarian, gender sensitive rural development, how whether or not it enables, the same process enables the promotion of women's right to redistribution and representation. So we have three scales of rights here that you that you bring forward through Fraser's scales of life, of three scales of rights, and you trace the advances or setbacks that this project of land restitution have brought to women's lives, the women's lives by tracing these three spheres of rights recognition or legal, juridical, economic empowerment. So I truly think that the way you ethnographically trace through multiple sites, both spatially and also by reading through different forms of archives, different forms of documents, what happened in this whole process where women, the displaced women, were first construed as subjects of rights and empowerment and redress, and how their empowerment is tied to the process of the process of projects of rural development. You resist giving a simple yes or no answer to this question. I mean, you do not simply ask a result-oriented question of, has this process of transition, initiative of transitional justice empowered women or not? You invite us, instead of this, you invite us to tracing at each level, or at different levels of this whole restitution process, how women, displaced women, are construed, enfranchised, and empowered or disempowered as rights-bearing subjects, which, this whole discussion, I have to say, impresses me also as a fellow anthropologist. But I'm not gonna dwell too much into that. But why it is impressive, I'm just gonna try to summarize in my own words what you mean by elusive justice, and it's in that attempt at some summary that I'll also pose my own questions or insert my comparative reflections on what the Colombian experience tells us, not only with respect to the immediate historical ethnographic context, but vis-a-vis also similar processes of violence, dispossession, and gender-sensitive restitution or redress in post-conflict societies. The concept of elusive justice, I think, is the first of all, I find it very productive in how it enables us to envision, to understand the project of justice as always already incomplete, partial, open to negotiations, open to setbacks, and open to conflicts and spaces for agency. And at different points, at different scales, you very productively show us how justice is elusive, not because of a simple answer to its absence or existence, but because of the need to attend to different actors and their interests, perceptions, understandings, and needs in debates over the definition of justice. So yes, or no, with such a processual understanding of justice as something that is always already open to negotiation, displacement, and rearticulation, enables, I think, enables us to not to be dismissive of what is often dismissed as legal enfranchisement of women unaccompanied by their social and civic or economic empowerment. You show how, even if women have not, women's socioeconomic rights have not been have now advanced as well. The very fact that the fact that women's eligibility for the right towards owning property in a society historically, in a society that historically denied women the right to patrimonial, to right to patrimony or land ownership, how the definition of women as rights-bearing subjects for property and for restitution of the harms they suffered during the internal warfare is significant in the has significant repercussions on their social citizenship status, on the status privileges or that they can claim and hopefully enjoy beyond the constraints of patriarchy or war-induced capitalism, etc. I also find, that this sheer significance of legal and social codification of women as right-bearing subjects for holding properties, as right-bearing subjects for redress the redress of their rights violated during the period of conflict is significant because it brings them into the negotiations of the socio-political and cultural order to come as agents, as equitable right-bearing subjects. And even if this may not always be accompanied by their substantial socioeconomic empowerment, as you say, this is a development. The legal enfranchisement of women is a development that is not to be despised nor sacrificed with any result-oriented analysis. I also find your emphasis on the second emphasis that you have on articulating elusive justice concerns the production of legal truth and how the production of legal truth not only enfranchises women, but the production of the category of victimhood, the category of harm, and the category of redress itself is always gendered, and it may have positive or negative implications on the negotiation of gendered nature of harm and gendered projects for restitution. I think what I was meaning to suggest here in more like plain terms was I found your discussion on how the legal the legal process, the juridical process itself re-articulates through various institutionalized knowledges of bureaucracy, local patriarchy, or the international norms of victimhood and legal redress. How it provides a ground where justice remains always elusive, because the ones who codify legal truth, who codify or decide upon what constitutes truth in a legal sense, are not the same as the ones that are codified as victims legally. One example that you mentioned in the paper, which I thought was really significant and wanted me to ask, how different regimes of how different knowledges with which the courts establish victimhood and the women testify as legally legally decodifiable or legally trustworthy victims there was this, okay, I lost it somewhere, but there was this example where you said when a judge dismissed a rape case, in a rape case, when the woman's testimony, he thought, was inconsistent, even though the formal letter of law took away the burden of proof from women in cases of rape or sexual violence, it was the judge's discretion that the victims, the claimants, testimony did not fit or measure up to the requirements of legal truth because it was inconsistent. I was just wondering how, is there a continuity between, and you tell in various places how women's lack of expert knowledge or bureaucratic language through which to claim their land rights, to claim their ownership of land, undermines their credibility in courts of law as subjects that are that deserves restitution. So this level at which women's knowledges, in this case, displaced rural women's knowledges, how it clashes with the bureaucratic language itself, with the bureaucratic and legal requirement for the production of testimonies and the restitution of losses. That discrepancy itself, leaves again the process of justice elusive because it ends up, or it runs the risk, always runs the risk of ending up discrediting the victim, the claimant as a trustworthy, hence right-bearing subject. At this, I thought also the justice is elusive at this point, at the production of at the production of legal at the point of the production of legal redress, because legal redress itself, or conviction or restitution itself, usually leaves women facing myriad vulnerabilities that are posed by their communities, such as shaming, public shaming, ostracization, etc. Vulnerabilities posed by the increasing numbers of militaries or generally militarized socioeconomic order, and how it also falls short of endowing them with skills to secure livelihoods in their status as post victims. Another, at this point, another point that that caught my attention was how that's again this knowledge of elusive justice at the point of, at the sphere of the articulation or definition of victim. Victim has to remain elusive because the definition of victim itself has its own, the definition of victim and perpetrator itself does not do justice to the myriad ways in which people exist in, or people simply survive in contexts of warfare and endemic or endemic conflict. I was thinking about the opponents to the land restitution cases, who are not perpetrators, who are not members of paramilitaries, who are not state agents, but who happen to be opportunist middle farmers, or who happens to have been resettled in displaced lenses by paramilitaries as part of their patron-client politics, or settled to those abundant displaced lands as by the state, or who in a series of process of displacement just happened to find, of course, through various protection mechanisms, find an opportunity for survival and livelihood there. So what happens to these people who are not strictly perpetrators not perpetrators in the strict term of the term, in sense of the term, but who cannot qualify as victims in legal terms as well? What happens when the restitution is achieved for the ones who are dispossessed? What happens then? Those people who would face a second or perhaps a third or fourth process of displacement from the restituted areas. I have in mind this question because in my area in my research area, the question of land restitution is such a thorny issue, be it when you're talking about the Armenian genocide or talking about, the systematic depopulation of the Kurdish countryside in Kurdistan of Turkey, or if you're talking about depopulation policies or displacement, not only as a direct effect of warfare, say in Syria, for instance, but displacement as an integral part of demographic engineering policy used in different parts of Syria, for instance, by the Assad regime or by different jihadist groups, used in Turkey for the case of Kurds and Armenians and Greeks before them. So what happens? Say, for instance, in the projects in imagining land restitution for victims of Turkish state violence in Kurdistan of Turkey, or for victims of the Syrian conflict who were dispossessed as part of demographic engineering policies, what will happen to people who have been resettled in their places? Is it clear? I'm not sure. But that was one question that you pose. Not question, but issue that you pose when debating why justice has always to remain elusive, even in the delineation of the categories of victims and perpetrators. And then finally, I thought your articulation of elusive justice also gives us the concept of elusive justice also is significant when you question the legal closure that is imposed upon the category of victim in all transitional justice processes. This is where legal articulation, the definition and the redress of harm, be it when we are talking about sexual violence or land expropriation or people or extrajudicial executions, massacres, etc. The legal restitution itself in all transitional justice processes, and apparently in this case too, envisions a closure in the category of victimhood, and also in a closure in a temporal closure as well, where the harm that is redressed belongs to the past of a conflict period, and in the post-conflict society, that harm itself is supposed to be left behind. Or the post-conflict, I'm so sorry. Okay. So this region, this temporal regimentation in transitional justice processes between conflict and post-conflict, how legal adjudication itself imposes a closure that may not have any relevance in the real lives of victims. I just want to close with just two questions. But again, I mean, despite together with all these, I think very like insightful and stimulating debates on the possibilities and limits of legal recognition of legal enfranchisement in this particular case. You also look at, how legal enfranchisement has not been accompanied or is not paralleled by a process of socioeconomic enfranchisement, as these women were rendered, landholders with deeds, and they were asked to return and act as agents in a rural development plan, or in a rural economic development model that functions on that functions or that operates according to through the relations and according to the contingencies of an armed neoliberalizing process. It feels as if the state. Should I just cut here? And if I
think so, because we don't have much time for questions.
I'll ask my questions on that ground later.
But I don't know if Dr. Marston wants to reply, or should we open up for, we only have 6 minutes left.
Maybe not extend, perhaps.
Donnie, are you there?
Yes. I had my mic closed. So, well, there are so many questions I would like to discuss, but I think it takes me a lot of time. And, well, I only want to say that the idea of victimhood and the idea of what happened to people who desettled. These are all categories. Well, in part, I will talk about this in my book. I think it's too much to answer all these questions, but I'm very happy with all those questions, because it takes me at least another article to answer them. But I think part of it, they are the definition of victimhood itself, the question of the difficult, the differences sometimes are blurred between perpetrators and victims, and there are all categories that are nor victims nor perpetrators, or both. And this is very, very quick. And this is, I think, a very important subject to work more on it. And this has also consequences for the whole return process and for the building of new livelihoods in the countryside. I think this is where this is also a question of how to categorize those women, and they don't feel identified with the categorizations, even if they accept to be a claimant for a land restitution. I think these are all very interesting processes. I just want to mention one thing, and that is that sometimes there is a difference between those women who organized in the cities as displaced persons and had a very long experience of organizations and of claimants for equity to a government. They not always are the same persons that became claimants for return of land, for the restitution of land. So there may be also differences of claimants, of victims, of organized women who claim for more general aspects of citizenships and are not connected to those women that are in the small category of victims of land dispossession. Although they all have been victims of land dispossession, but some are just using other categories, more broader categories of citizenship. Well, and this complicates very much the process of social organization and the future of what is made of the peace process. Well, I will leave it with this.
I was thinking it also invites an engagement with individual case by case basis of rights restitution and the development of collective projects at restitution, and be it the land reform or rural development or rural development model itself.
Yes, I think there is a individualized as claimants for land restitution. They don't, they're by some seen as too much involved with state policies. Yeah.
Mm-hmm.
And they are seen as not combative and as not pushing for, for instance, for land reform and for more broadening the social citizenship of women, because they were captured by the state in this particular restitution process. I think this is one. The other one is what you told about the desettled. There are very, very complex processes that don't enter in the restitution process because they are too complex. The state does not want to touch them, or some of them at an individual basis. But there are places where the paramilitary resettled people, poor people, and now there are former land redistribution, land reform areas where old combative peasant movement leaders are cohabiting with the poor people that were put there by the paramilitaries. And there were other people were displaced, and they put in a claim for land restitution. So there are 3 categories or 4 categories of victims or non-victims or perpetrators trying to live together in the same community.
I'm gonna have to interrupt because we run out of time.
Yeah.
This is,
Okay,
I know
okay.
this is
so-
an extremely complex issue, and I really appreciate both the work that both of you do about a very important topic that we need to keep on looking at. And we really need to, I think, look at the issue of how are women being empowered? How can they empower themselves to change this balance of power? It is very difficult to do in a situation of conflict, as it is in the case of Colombia and many of the places where Dr. Schengel is also working. This is, incredibly challenging work, and I congratulate both of you. And I would invite the audience, to maybe send questions by email. We can provide, if you can provide your emails through the chat, and we can put you in contact with our presenters today. If you have specific questions, because we unfortunately run out of time. Thank you both. I think we need a second session for this. But I do encourage everyone to read their work. This is, I have a ton of questions. I got questions about issues of race, issues of ethnicity, and how do they intersect with the issues, especially in the Atlantic coast of Colombia, where you have so many different ethnicities at the same time coexisting. What happened with women ex-combatants who then go back. So anyway, thank you so much, everyone. And I would please stay for a little longer for those. I don't know if people want to ask a question now. Although we ran out of time, I don't know if you guys can stay 5 more minutes or so.
Can I say something?
Yes.
Yes, I saw a question
Yes,
about genocide.
yes.
Yeah, and
If you
well,
describe these events as genocide.
yeah, genocide, and well, my answer is it is much more complex. This is not a very original answer, but there are claims of genocide by certain acts of violence against, not in the case of guerrilla or paramilitarism, but their claims against the Colombian state because of the extermination of the UP, the Unión Política Patriótica, which was seen as a political party, as the political arm of the FARC, and they were they won many votes in elections, and they had mayors and on the mayor and other levels, regional levels, and many of them were murdered by, well, both military and paramilitary forces. And this is a case that is brought to the Inter-American Constitutional Court, the Court for Human Rights, as a case of genocide, which is still not accepted by the Colombian government.
Right.
But this is just a part of what has been 50 years of violence in Colombia.
Yeah, that same person asked about international intervention against it, but hasn't happened.
There were some international interventions in, well, you can see Operación Colombia, but not directly against this kind of violence. It was more, I think there was no official international intervention. It was related to the drug economy, not to well, all those other different expressions of violence in Colombia.
Mhm. Well, thank you, everyone who stayed. And I hope that next time we can bring you in person.
May I just ask one question that you mentioned also, not question, but remark, and that you also mentioned, Marcela. I was just thinking throughout it. I'm sorry, I just mismanaged time, but how does the clause of gender works here, not in an intersectional way, but presupposes and perhaps provincializes in its course the ethno-racial dynamics of conflict also lent dispossession throughout the conflict in Colombia, because this is not we're not seeing here an intersectional take on gender and on gender violence or restitution, right? It's the gender is at one level, and in this whole restitution process, race, ethnicity, race, I understand, is not a category that the Colombian government is you know, fun to speak about, but it is there. Ethnicity is another category, and the rights of indigenous women, for instance, how their rights to restitution is sacrificed with another kind of both like patriarchal alliance, right? Between among the Bogotan elite, you know, the local power holders and individual leaderships, and how such an understanding of gender as a non-intersectional factor, perhaps, or I don't know, I don't know, but that's the question, how it helps resuscitate the ideology of mestizaje, perhaps, you know, taking us back to the 1970s. That's what I mean, that's one thing that I have very little knowledge about, but I was wondering, you know, where does the, you know, where does indigenous or Afro-Colombian women and their rights stay in this overall all discussion or plus for restitution?
Well, I couldn't understand everything of your question because there was a bad connection for the moment, but well, I think that the social movements are so active and are so diverse, and there are all kinds of connections, and there are all kinds of institutional processes going on, that it's very difficult to say, well, I just want to mention a case to show how it is. There is a formal part of restitution to collective territories of indigenous people and Black people, Afro-American, Afro-Colombian people who also have collective territories. And this is a formal issue. And this is another aspect because this formal issue is hampered by those collective territories suffered a lot by the advancement of mining, of extractive industries. So even the government, they are not very active at this front. But I want to tell you an anecdote of the cross-cutting identities and cross-cutting categories of a case of collective territory, what was in a process of restitution of part of their land in the north of Cauca province. And then they told me that this recent participative regional planning, a group of Black women asked for land outside their territorial territories because they found that they had no opportunities in the collective territory for getting her full citizenships.
Right.
Yes. So they ask for outside
Mhm.
as a group of women, and they ask this in this participative process of regional planning issues, where everybody, all small organizations, could put their initiatives forward. So this is where you say that this is much more complex than
Mhm.
there are Black women's movements, there are indigenous women's movements, and they participate in different constituencies
Mhm.
in their indigenous territorial places, but also in women's groups,
Mhm.
for instance. So I don't know, as I didn't understand only part of your question,
Very
if this gives some illumination.
Well, yeah, communal land rights is what really makes the difference here. Yeah. Well, thank you, everyone. I think we're gonna close now. So thanks for the everybody that came.
Thank you very much for the opportunity.